Now the floor is for Michelle Finck, Professor Finck. Thank you very much for joining, and thank you very much for your speech in advance. Thank you. When you want. Professor Finck, can you hear me? The floor is yours, please, when you wish. We cannot hear you, I'm sorry.
Hi, good morning, everyone. I wasn't able to unmute myself, so apologies for the silence. I need to wait for you to do that. So let me also share my screen, and then I'm ready to get started. Can you see the screen?
Yes, we can see that.
Thank you for confirming. So yeah, good morning, everyone. Thank you so much for the invitation to be with you this morning. It's a real pleasure. So I'm going to shift gears a little bit and talk about the developments that are currently unfolding in EU data law and what they might mean for decentralized data ecosystems, including those applicable to virtual assets. So in my research, I mostly focus on data law and data governance. And that essentially means that I also look at the technologies that we're thinking about this morning through this perspective, thinking about how to match existing systems to legal systems to those technical systems, and also think about what the ongoing legal reform that we're having in the European Union might imply for those systems. Now, in the interest of time today, I'm not going to be able to talk about all the different regulatory frameworks that exist at EU level in this respect, but I'm going to focus on two of them, the GDPR and then also the proposed Data Governance Act, and try to draw out some of the implications that those legal systems have for decentralized data ecosystems, such as those that we see in relation to virtual assets. And you see possible in brackets here in my title, because of course the Data Governance Act is just a proposal at this stage. So its provisions might change over time, and what I'll about to tell you about it might no longer be true, maybe in a couple of years. Right. So what do I mean when I talk about decentralized network governance and decentralized data ecosystems? Well, of course, one of the technologies that we're thinking about most this morning is blockchain technology. And I think that at a starting point, it's really interesting to think about where the innovation that comes with blockchain or may come with blockchain actually lies. So I think many people approach this technology and think about, well, where is the technical innovation here? And of course, many people have rightly pointed out that actually it may be limited to the extent that, you know, blockchains are a sort of collage of existing technologies that have existed for a long time. So I personally think that it's more fruitful to think about blockchains as a form of institutional rather than technical innovation, to the extent that what it really does, or where its innovation might really lie, is in its ability to change existing institutional structures, notably in relation to how we govern data. And indeed, what many projects that are using blockchains are trying to do is to decentralize control over data, to no longer make it what it currently is, which is, you know, oftentimes centralized in one legal entity and others being able to access the data. So what decentralized projects by and large try to achieve is to decentralize the control over data across many different parties that may or may not know and that may or may not trust another, and thus also may or may not be able to coordinate, and that can also be based in different jurisdictions. And of course, those features are fundamentally at odds with current, or let's say, particularly past data governance models that we saw in the early decades of the data economy. And this, of course, also has legal implications from the perspective of EU data law, to the extent that data law, as we're about to see, always presumes a certain degree of centralization when it comes to data governance. And we can clearly see this when we look at decentralized data protocols from the perspective of European data protection law, essentially the general data protection regulation. Now, the GDPR is based on this notion of accountability, and essentially this means that the regulation foresees that the data controller, as the central figure in EU data protection law, needs to ensure that the various provisions of the GDPR are being complied with. Now, this of course raises the question of who actually is the data controller under EU data protection law, who is the central figure in charge of ensuring compliance with the GDPR. Well, the GDPR tells us that the data controller is an entity that controls the means. This essentially means the how, how is data being processed, as well as the purposes, that is to say, the why of the processing of personal data. And the GDPR also tells us that there can be more than one data controller at a time, right? So it explicitly foresees the possibility of there being joint controllers in relation to a single data processing operation. And at first sight, this looks like a rather easy task, right? The data controller is the person that controls the how, and the why personal data is being processed. However, over the past 10 to 15 years, we've really observed a gradual broadening of this notion of control, both through the European Court of Justice's case law, as well as through regulatory guidance. So the Article 29 Working Party announced in 2010 that the determination of the purposes would always trigger the qualification as a data controller, meaning that if you have a purpose as to why you're processing data, that in itself may be sufficient to qualify as a data controller, even where you have no or only very marginal influence over the means. And the European Court of Justice has, through 2 Grand Chamber judgments, also moved in that direction. So in a case from 2018, Wirtschaftsakademie Schleswig-Holstein, it held that there is a need to ensure a broad interpretation of this notion of the data controller in order to ensure the complete and effective protection of data subjects. So the idea here is that you need to interpret the notion of control broadly so as to catch many parties in order to make sure that data subjects have many parties that they can address in order to seek the enforcement of their data protection rights. And as a consequence of this broad rationale of ensuring the complete and effective protection of data subjects, the court in this case found that agreeing to someone else's determination of the means was sufficient to be a data controller where one pursues a purpose. So this really echoes the guidance by the Article 29 Working Party from 2010, that where you have a reason as to why you process data, which you of course always have when you process data, that in itself may be sufficient to qualify as a controller, even where you exercise no or only very, very little influence over the means of processing. And the Wirtschaftsakademie Schleswig-Holstein case has been confirmed by subsequent case law, such as the Jehovah's Witnesses case, in which the court reiterated its reasoning and held that a natural or legal person who exerts influence over the processing of personal data for his own purposes and who participates as a result in the determination of the purposes and means of that processing might be regarded as a controller. So we're seeing a really significant shift in the interpretation of the notion of the data controller under the GDPR, away from what the text of the GDPR itself would indicate, namely that you need to have influence over the purposes and the means of processing, away towards a test that is backed by the former Article 29 Working Party, as well as the European Court of Justice, whereby the purposes is really the determinative criterion. And this is really significant because it dramatically broadens the net of possible parties that qualify as a controller, to the extent that anyone that's processing personal data always have some current of purpose in doing so, right? Otherwise you wouldn't do it, excuse me. Now, what are the implications of this for blockchain-based decentralized networks, such as those that we're seeing in cryptocurrencies or digital assets? Well, essentially, it means that a whole range of actors that are based at different instances of the overall software stack may qualify as data controllers, right? Of course, you would need to carry out a detailed case-by-case analysis in order to figure out who specifically qualifies as a controller in relation to a specific application and use of this technology. But generally, a number of candidates have been identified in the literature that deals with those questions. So certainly applications that are based on blockchains could qualify as data controllers. When we look at the layer one of the software stacks, such as public and permissionless or private and permission blockchains, there's a number of different actors that could qualify as data controllers to the extent that they all pursue a purpose in processing the personal data that is being processed. These include software developers, miners or validators, depending on what consensus protocol is being used. They include, and significantly, the French Data Protection Authority has issued guidance which strongly suggests that even users may qualify as data controllers, and this even in relation to their own personal data that is processed in this, which, as I would suggest, turns the data protection somewhere on its. Now, there's two broad concerns that are associated with this broadening of legal liability for data protection. The first one is lack of legal certainty. Now, anyone thinking about using a decentralized data governance structure will really struggle to figure out how to apply the existing legal framework to their project, particularly in relation to the determination of who the data controller is in relation to a single data processing obligation. The second question, which I think is also very significant, is that actors that have no technical ability to actually exercise the obligations that arise under the GDPR may be legally required to do so. Right? Because of this widening of the definition of who the data controller is, there is now a situation in which parties that have no access to the actual data or to the software that is being used to process the data can qualify as data controllers under the GDPR, meaning that they should be in a position to do things such as erase the data, describe to others how the data is being processed, etc. Yet they are unable to technically do so. And this sort of practical aspect of the qualification of the data controller was not dealt with in the court's case law that I mentioned earlier on. And I think this is certainly something that the European Court of Justice will have to grapple with in the years to come. Now, let me move on to data governance. What I've tried to show in relation to the GDPR is that data protection law is certainly still based on an of centralization that is no longer necessarily the case when we look at practical use cases of technologies such as distributed ledgers. Now, the Data Governance Act is different in this respect to the extent that I would say it actually implicitly tries to encourage a decentralization of how data is being governed. Now, the Data Governance Act is a proposed piece of EU secondary legislation. So as I said in the beginning, this is something that was just put forward by the European Commission about 6 months ago. It will certainly take years before it becomes law. We don't necessarily know what it will look like at this stage and if it will successfully result in a piece of legislation. But what the Data Governance Act tries to do at this stage is to create various different mechanisms that would result in a stronger sharing of data, both personal and non-personal data, in the EU. And one of the ways in which the Data Governance Act tries to achieve this is by creating a light touch notification framework for providers of data sharing services. And essentially, the idea here is that by incentivizing data sharing services, you move away from more centralized forms of control over data to the extent that data sharing services, it's hard to provide a sort of single definition of what a data sharing service is because there's that only a nascent industry of data sharing services in the EU, but they all take different forms. They use different technologies, they have different business models, etc. But what they all have in common is that they try to make it easier for various parties to share data with others. So there's essentially a form of intermediaries to that try to facilitate the sharing of both personal and non-personal data across a variety of actors and institutions. So essentially what they try to do is to decentralize the way in which data is held and to decentralize the way data can be accessed by others. And the Data Governance Act explicitly tries to encourage stronger reliance on data sharing services by giving business models a legal framework that they can base their activities on. And the first thing to really note what the Data Governance Act tries to do in this respect is that it is only tech agnostic. So it could certainly catch some of the data services, sharing services that already exist, which use blockchains part of the technical infrastructure. And you can see that the Data Governance Act is tech agnostic, for instance, to the fact explicitly provides that for data could take any form. So you don't need to take for the data through fiat. You can also be a data sharing that's governed under the Governance Act that has some kind of token, for instance, in order to pay for the data that you can access and share. And I think this really illustrates this objective of trying to facilitate access to data and encourage a variety of different data sharing services in the EU are in turn expected to result in more data-related economic growth and innovations for the EU. However, I think it's also important to point out that there's limits to the decentralization that can occur here. So the Governance Act, in its provisions related to the notification framework, has a number of very specific legal provisions that would still require that there is a centralized legal entity behind the data sharing services. And this, of course, is something that we are now, there's currently a trend in sort of the decentralized business models that try to move away from still having this centralized legal entity. So for instance, if you look at decentralized exchanges in the crypto assets world, you can see this clear trend towards trying to do away with the existence of a centralized legal entity behind a given provider. And there is a clear limit in the Data Governance Act that would not make this possible for data sharing services to the extent that it requires that there is a centralized legal entity behind the data sharing service. And of course, there's very valid policy objectives as to why you would want this to be the case. Now, I'm looking at the time and I'm realizing that I should wrap up. So let me move on to my concluding thoughts. So I think generally, if we look at the development of the regulatory framework around data governance in the EU, there is somewhat of a recognition that decentralized data networks, such as the data sharing services that have come into existence, can be a beneficial development for the data economy in the EU, and hence also help strengthen EU competitiveness in areas such as artificial intelligence or the data economy more broadly. However, particularly legal frameworks that have been in existence for a number of decades already imposes very clear limits on the extent that decentralization can actually assume in this context. We've seen this by looking at the figure of the data controller on the data protection law, where I don't necessarily agree with the legal definition that has been embraced by the court and regulatory guidance in this respect. And I think that the broad definition of the controller is actually antithetical to some of the objectives that data protection tries to achieve. But in turn, we can also see in the Data Governance Act that the law actually imposes limits on decentralization in order to achieve recognized policy objectives that are hard to disagree with, right? I mean, there's very valid reasons why throughout centuries we wanted there to be a centralized legal entity that we could easily assign responsibility to if something goes wrong. And the Data Governance Act certainly continues this definition and this approach, even if it means that there can't be a sort of 100% decentralized data sharing service that would be aligned with what some of the decentralized exchanges are, for instance, trying to do. I think we definitely need further clarification how to map some areas of data law to more decentralized structures. I think this is, very clearly the case in relation to the data controller, and this is actually something that the European Data Protection Board has been working on. And then more generally, I think one thing to take away from this research is that data law just generally highlights some of the legal challenges that come with organizational innovations. This is something that's been true throughout human history, so it's unsurprising that it would also be true in relation to the technologies that we are interested in this morning. And with this, I stop, and I'm very much looking forward to the discussion. Thank you.
Professor Finck, thank you very much. It has been a pleasure to hear you. Thank you also for sticking to the time. You are making my work very easy. Thank you very much.